Welcome back to Criminal Procedure CRJU 201A. Today we're going to be discussing searches and seizures. Today, you will seek to understand the reason the Fourth Amendment was included in the United States Constitution, know the relationship between the expectation of privacy and the Fourth Amendment, understand whether the Fourth Amendment allows undercover agents and informants to conduct warrantless conversations with criminal suspects, understand plain view searches, understand the expectation of privacy and protections provided by the Fourth Amendment, know the different Fourth Amendment protections for open fields and curtilage, understand technology in the Fourth Amendment, understand cell site location information, and understand the Fourth Amendment and seizure of persons. The Fourth Amendment and searches and seizures are truly one of the most important aspects of criminal procedure, and many attorneys make their living on arguing these points. The investigation and prosecution of crime requires the collection of evidence, which may be physical or testimonial. Some investigations are straightforward, where eyewitnesses identify the perpetrator, forensic evidence is found at the scene, or suspects may voluntarily cooperate. However, it's more often the case that such evidence is unavailable. Eyewitnesses may be unwilling to come forward, forensic evidence may point to multiple suspects, and individuals may refuse to cooperate. In these situations, police typically rely on other methods of collecting evidence. These may include searches and seizures, interrogations, identifications. The primary purpose of searches and seizures is to gather evidence to support the investigation of the criminal activity. These may include instrumentalities, which are items used to commit the crime, fruits, which are the property obtained during the crime, such as money, jewelry, or other stolen goods, contraband, which is illegal drugs or other prohibited items, the evidence of criminal activity, which could be items covered in blood or gunpowder residue, and incriminating statements, which must be obtained via lawful surveillance. The Fourth Amendment protects individuals against unreasonable governmental searches and seizures. The Fourth Amendment applies to only government action and not to that of private individuals, unless those private individuals are acting on behalf of the government, which we will discuss. There are 4 areas protected by the Fourth Amendment: persons, houses, papers, and effects. A person is protected against unreasonable detention and searches of their person. Houses includes residences, dwellings, and areas immediately surrounding the home, as well as certain private businesses. Papers includes letters, diaries, and business records, and most recently, cell phones. And effects include personal possessions, such as vehicles, clothing, and firearms. The amendment allows searches and seizures for evidence of unlawful activity, provided they comply with its requirements. The Supreme Court has spent decades interpreting the Fourth Amendment, balancing society's interest in investigating crime against individuals' interest in privacy. There's a 3-step analysis in addressing the Fourth Amendment. There can be exclusion from evidence. If the search or seizure was unreasonable, does the exclusionary rule require that the evidence be excluded? I'll go ahead and give you a flash into the future. It is very rarely used. Did the government conduct a search or seizure as defined by the Fourth Amendment? And was the search or seizure lawful? This chapter focuses on the Fourth Amendment searches and seizures of individuals. As technology advances, courts continue to evaluate whether intrusions, such as obtaining DNA samples, monitoring emails, or searching cell phones, constitute searches requiring a warrant or may be conducted without judicial approval. The Fourth Amendment was included in the Bill of Rights to protect individuals from the far-reaching searches and seizures conducted by British authorities in the American colonies. Colonists were particularly angry about the use of general warrants and writs of assistance, which allowed officials to search homes, businesses, and warehouses for smuggled goods to enforce custom duties. Searches were also used to seize able-bodied young men for forced service in the Royal Navy. A general warrant was issued by a judge or a government official and authorized searches anywhere, at any time, and for anything. A writ of assistance was a form of general warrant that empowered officials of the English Crown to compel police officers and citizens to assist in a search. Once issued, these documents remained effective for the life of the sovereign and did not expire until 6 months after the sovereign's death. In 1761, the Writs of Assistance case involved 63 Boston merchants challenging the Massachusetts Superior Court's authority to issue writs of assistance. The court ruled in favor of the government. Attorney James Otis argued that such writs were destructive of English liberty and the fundamental principles of law, emphasizing that one of the most essential branches of English liberty is the freedom of one's house. A man's house is his castle. This writ, if it should be declared legal, would totally annihilate this privilege. Colonial legislatures responded by prohibiting general warrants. For example, the Virginia Declaration of Rights in 1776 declared that general warrants are grievous and oppressive and ought not to be granted. Over time, both English and American courts began to rule illegal and void any search warrant authorizing searches of all persons or places indiscriminately, insisting that warrants be issued only when there was probable cause to believe contraband was in a specific place. The Fourth Amendment reflects this historical context. It abolished general warrants and writs of assistance by prohibiting unreasonable searches and seizures and requiring that no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. In other words, the government must present evidence to a magistrate or judge showing probable cause that evidence of or contraband is located in a specific location at a specific time. A general warrant would be considered unreasonable under this standard. While the Supreme Court prefers searches to be conducted under warrants founded on probable cause, it has recognized circumstances where warrantless searches are reasonable, particularly when designed to protect public safety rather than gather evidence for prosecution. These special needs searches include security screenings at airports or inspections at national borders, which protect the public while minimally intruding upon individual privacy. The Supreme Court's approach to the Fourth Amendment has evolved from a property rights model to an expectation of privacy model. In Boyd v. United States, the court protected individuals against physical intrusions or trespasses on their persons, houses, papers, and effects. For an intrusion to occur, there must be an actual physical entry into a home, person, or possession. The Fourth Amendment protects persons, houses, papers, and effects. Justice Hugo Black summarized this perspective in Katz v. United States, stating that the amendment was aimed directly at the abhorrent practices of breaking in, ransacking, and searching homes and other buildings and seizing people's personal belongings without warrants issued by magistrates. The limitations of this approach were highlighted in Olmstead v. United States. Roy Olmstead was convicted of conspiracy to unlawfully import, possess, and sell liquor, based largely on evidence obtained through warrantless wiretaps. The court, in a 5-4 decision, held that conversations transmitted across telephone wires did not involve a physical object, and that wiretaps placed outside the home did not constitute a physical intrusion. The court concluded that the Fourth Amendment could not be extended to cover telephone wires reaching to the whole world. In his dissent, Justice Louis Brandeis argued for a broader interpretation, emphasizing the constitutional right to be let alone and asserting that every unjustifiable intrusion upon the privacy of the individual by whatever means employed must be deemed a violation of the Fourth Amendment. This approach was reaffirmed in Goldman v. United States, where the court held that installing a detectaphone on an adjoining office wall did not violate the Fourth Amendment. In February 1965, Charles Katz was observed making calls from a bank of 3 public telephone booths during specific hours on an almost daily basis. He was not seen using any other booths. Between February 19th and 25th, 1965, FBI agents placed microphones on the tops of 2 of the telephone booths. The third booth had been taken out of service, so there was no risk that Katz would use it. The microphones were attached to the outside of the booths with no physical penetration inside and activated only when Katz approached and used the booth. Wires ran from the microphones to a recorder. Using these recordings, the FBI documented Katz's telephone conversations. The recordings revealed that Katz's calls involved placing bets and obtaining gambling information. On February 23rd, FBI agent Alan Frey rented a room adjacent to Katz's residence and overheard Katz's conversations through a common wall, taking notes. These notes, together with the recordings from the telephone booths, provided the basis for a search warrant of Katz's apartment. The warrant targeted bookmaking records and wagering materials, including bet slips, markers, rundown sheets, schedule sheets, adding machines, money, telephones, and telephone listings. During trial, evidence showed that from February 19th to 25th, Katz made calls from 2 booths on the 8200 block of Sunset Boulevard in Los Angeles, excluding February 22nd. The transcripts and telephone company records showed that the calls went to Boston and Miami. The court found that Katz's activities were indicated a business of betting or wagering. He was convicted under an 8-count indictment for transmitting wagering information by telephone to Miami and Boston. The Court of Appeals upheld the conviction, finding that the recordings did not violate the Fourth Amendment because no physical intrusion into the telephone booths had occurred. The Supreme Court granted cert to consider whether the warrantless surveillance of Katz's conversation violated the Fourth Amendment. The key question was whether Katz's conversations were entitled to constitutional protection, regardless of the absence of physical penetration into the booth. The court held that the Fourth Amendment protects people, not places. What a person exposes to the public is not protected, but what is intended to be private, even in a publicly accessible area, may be constitutionally protected. Katz sought to exclude the uninvited ear, not the intruding eye, by closing the door of the telephone booth. The court noted that a person who occupies a booth, closes the door, and pays to place a call is entitled to assume the privacy of their words. The government argued that the absence of physical penetration precluded Fourth Amendment concerns, but the court rejected this, emphasizing that property interests no longer control the right of the government to search and seize. The Fourth Amendment governs not only tangible items, but also the recording of oral statements without technical trespass. The court concluded that electronic surveillance of Katz's words violated his justifiable expectation of privacy and constituted a search and seizure under the Fourth Amendment. Regardless of the lack of physical intrusion, the court held that warrantless searches are per se unreasonable under the Fourth Amendment, subject only to a few well-established exceptions. Katz's case demonstrated that the agents acted without judicial oversight, making the surveillance unconstitutional. The judgment was reversed. In his concurring opinion, Justice Harlan emphasized a twofold requirement for Fourth Amendment protection. An individual must have a subjective expectation of privacy, and society must recognize that expectation as reasonable. Katz's conversations in the closed telephone booth met both criteria, even though the booth was temporarily public. In dissenting, Justice Black argued that the amendment protects tangible things and that conversations overheard by eavesdropping or wiretapping are not subject to its protections. He maintained that the court was improperly extending the Fourth Amendment to cover future conversations and that interpreting it in this way exceeded judicial authority. According to Black, the framers understood eavesdropping as a known practice and would have specifically prohibited it if intended, rather than leaving it to judicial interpretation. Patricia McDonough was robbed in Baltimore, Maryland on March 5, 1976. She provided the police with a description of the robber in a 1975 Monte Carlo automobile she had seen near the scene. After the robbery, McDonough began receiving threatening and obscene phone calls from a male who identified himself as the robber. About 2 weeks later, the police spotted a man driving a 1975 Monte Carlo who matched the description provided by McDonough. The license plate was traced to Michael Lee Smith. The next day, the police requested the phone company to install a PIN register at its central office to record the numbers dialed from Smith's telephone. They did not obtain a warrant. The PIN register showed that on March 17th, Smith called McDonough's home. The police used this information to obtain a search warrant for Smith's home. During the search, they found a phone book with a page turned down to McDonough's name and number. Smith's motion to suppress the evidence derived from the PIN register was unsuccessful, and he was convicted of robbery and sentenced to 6 years in prison. The United States Supreme Court distinguished this case from Katz v. United States. Unlike the content of a telephone conversation, the court held that individuals do not have a subjective expectation of privacy in the numbers they dial. By using the phone, a person voluntarily conveys the numbers dialed to the phone company, which maintains records for billing and other legitimate purposes. Society is not prepared to recognize a reasonable expectation of privacy in dialed numbers, and an individual assumes the risk that the company might reveal this information to the police. Justice Potter Stewart dissented, arguing that there is a legitimate expectation of privacy in the numbers dialed, noting that PIN registers reveal the identity of people called and the places dialed, disclosing intimate details of a person's life. Justice Thurgood Marshall emphasized that the telephone is essential to modern life, and users have no alternative but to transmit numbers to the phone company. The concern, he argued, is not the risks individuals voluntarily accept, but the risks they should be forced to assume in a free society. The case raises the question of whether police should have access to dial numbers without a warrant. Some state courts, including those in Colorado, Hawaii, Idaho, New Jersey, Pennsylvania, and Washington, have interpreted their constitutions to provide greater protection than the Fourth Amendment and prohibit the warrantless use of PIN registers. In United States v. Forrester, the Ninth Circuit Court of Appeals relied on Smith to hold that a warrant was not required to install a mirror port that allowed the government to learn the to/from addresses of emails, IP addresses of websites visited, and the volume of information sent to and from a suspect's account. In 1976, in the United States v. Miller case, the Alcohol, Tobacco, and Firearms Bureau began investigating Mitch Miller and several co-conspirators who were later charged and convicted of various federal offenses for manufacturing and selling whiskey without paying the required federal tax. Grand jury subpoenas were issued requesting Miller's financial records from the Citizens and Southern National Bank of Warner Robins and the Bank of Byron. The banks, without informing Miller, provided microfilm records to a federal agent and turned over checks, deposit slips, financial statements, and monthly statements. Copies of the checks were introduced at trial. Miller claimed that the government had engaged in an unlawful search and seizure of his records in violation of the Fourth Amendment. The United States Supreme Court held that Miller did not have a reasonable expectation of privacy in his financial records. The court reasoned that the records contained information voluntarily conveyed to the banks and exposed to their employees in the ordinary course of business. The depositor assumes the risk that the information may be conveyed to the government. The court noted that it had previously held that the Fourth Amendment does not prohibit the government from obtaining information revealed to a third party and conveyed to authorities, even if the information was shared with the expectation that it would only be used for a limited purpose, and that the confidence placed in the third party would not be betrayed. The Sixth Circuit Court of Appeals in 2010 in the United States v. Warshak relied on Katz, Smith, and Miller in deciding whether Stephen Warshak possessed an expectation of privacy in the content of his personal email account. Warshak was convicted of various charges stemming from a scheme to defraud the customers of his company, Berkeley Premium Nutraceuticals, Inc. The U.S. government obtained a court order directing Internet Service Provider, ISP provider, Nuvox Communications to give government agents information involving Warshak's email account. This included the contents of wire or electronic communications that were placed or stored in directories or files owned or controlled by Warshak, as well as all log files and backup tapes. The Sixth Circuit Court of Appeals held that while Warshak assumed the risk that the recipient of a communication would reveal the contents of emails, he maintained an expectation of privacy in regard to his ISP. The ISP was not expected to access the emails in the normal course of business, and Warshak maintained an expectation of privacy in the content of these communications. Otherwise, phone conversations would never be protected, merely because the telephone company can access them. Letters would never be protected by virtue of the Postal Service's access to them, and the contents of shared safe deposit boxes or storage lockers would never be protected due to the bank or storage company's ability to access them. Compelled disclosure of subscriber information and related records are records of the service provider as well, and may be accessed by employees in the normal course of their employment, and access to these records likely creates no Fourth Amendment problems. However, there is a heightened expectation of privacy regarding the contents of email communications that society considers reasonable. Email is an ever-increasing mode of private communication, and protecting shared communications through this medium is as important to Fourth Amendment principles today as protecting telephone conversations has been in the past. The ISP's right to access emails under the user agreement is reserved for extraordinary circumstances. The outcome may differ where a user agreement calls for regular auditing, inspection, or monitoring of emails. The fact that emails may be scanned for pornography or a virus was not considered by the Sixth Circuit Court of Appeals to invade an individual's content-based privacy interest in the emails, and has little bearing on his expectation of privacy in the content. This is analogous to the post office screening packages for drugs or explosives, which does not expose the contents of written communications. In United States v. Post, the court held that an individual does not have an expectation of privacy in files posted on the World Wide Web that are not password protected. Investigators found an image that revealed a crime and used generally available software to determine the GPS coordinates where the photo was taken. The suspect was found and arrested at this location. The court held that the defendant waived his right to privacy in the image containing the GPS coordinates after it was posted on the internet. The U.S. Supreme Court upheld the reasonableness of a police department's non-investigatory search of an officer's texting records for the work-related purpose of ensuring that the city was not paying for extensive personal communications in Ontario v. Kwan, 560 U.S. 746, 2010. The Supreme Court has distinguished between government eavesdropping and situations where a person talks to an undercover agent or informant. In Katz, the court held that a person has a reasonable expectation of privacy in phone conversations, requiring a warrant for government monitoring. However, in false friend cases, where a suspect voluntarily confides in an informant or agent, the court has held there is no Fourth Amendment violation because the suspect assumes the risk that the information may be shared with law enforcement. In United States v. White, the court extended this principle to situations where the informant is wired, ruling that electronic recording does not violate privacy if a non-wired informant would have exposed the same information. Critics, like Justice Harlan, have argued that this approach undermines trust and security in private conversations. Some state courts, such as Montana and State v. Getz, have offered greater protection, holding that recording conversations in a private home without consent can violate privacy expectations. The key principle is that individuals risk disclosure when confiding in others, but debates remain over whether privacy expectations differ in homes versus public settings. The plain view doctrine is an exception to the Fourth Amendment warrant requirement. It allows police to seize evidence without a warrant if the officer is lawfully present and it is immediately apparent that the item is connected to criminal activity. When an individual exposes an item to plain view, they lose any expectation of privacy in it. For instance, drugs or an open container of alcohol visible during a traffic stop may be lawfully seized, and illegal items discovered while executing a valid search warrant may also be taken. The Supreme Court clarified that plain view does not require the officer to discover evidence accidentally. In Horton v. California, officers who were actively looking for evidence could still seize it if they were lawfully in the area. However, in Arizona v. Hicks, moving or manipulating an item to determine its legality exceeded the bounds of plain view, so the seizure was invalid. Courts have also recognized related doctrines, such as plain feel, where contraband is discovered during a lawful pat-down, plain smell, such as detecting odors of drugs or alcohol, and plain hearing, which is when officers overhear conversations where there's no reasonable expectation of privacy. Plain view often intersects with searches of open fields and curtilage and raises questions about how technology might enhance an officer's ability to observe or detect evidence. Understanding plain view helps define the balance between law enforcement needs and individual privacy protections. The United States Supreme Court has divided the home and the land around it into categories with different levels of Fourth Amendment protection and expectations of privacy. Open fields refer to the land far from the home. Police may enter these areas without a warrant or probable cause as they carry little to no expectation of privacy. The home itself, the structure, is fully protected under the Fourth Amendment, and police generally need a warrant based on probable cause to enter. Curtilage, the area immediately surrounding the home, is considered part of the dwelling. While it is protected, it has no expectation of privacy from aerial surveillance. Other property types also carry limited or no privacy expectations. Public property, which is generally open to all, can be accessed by police without a warrant. Commercial property, such as stores or businesses open to the public, may be entered without a warrant, although areas reserved for employees typically require one. Finally, abandoned property, intentionally discarded or relinquished, has no expectation of privacy and can be seized by police without a warrant. The Supreme Court distinguishes between open fields and curtilage, giving each a different level of Fourth Amendment protection. Open fields are areas of land distant from the home. In Oliver v. United States, police entered a marijuana field more than a mile from the home despite no trespassing signs and discovered the illegal activity. The court held that open fields are not protected by the Fourth Amendment because the amendment is intended to protect intimate activities. Open fields are accessible to the public, and monitoring them is relatively easy. Efforts to conceal activities or post warning signs do not create a reasonable expectation of privacy. Curtilage is the area immediately surrounding the home and is considered part of the dwelling. It is protected because it is the site of private activities such as recreation, socializing, and other intimate uses of the home. In United States v. Dunn, the court set out 4 factors to distinguish curtilage from open fields: distance from the home, enclosure, function, and steps taken to protect the area from observation. For example, a barn located outside the home's fence and not used for intimate home activities was considered part of open fields, and officers did not need a warrant to search it. Some state courts have gone further, giving open fields protection when fences or signs indicate a reasonable expectation of privacy. In Florida v. Jardines, the Supreme Court reaffirmed the high expectation of privacy in the curtilage. Police, accompanied by a drug-sniffing dog, entered the front yard of Jardines' home to investigate a tip without a warrant. The court held that this constituted an unconstitutional search because the curtilage is an extension of the home, and the police exceeded the implied license any visitor has to approach a front door. A physical intrusion into the curtilage to gather evidence, even with a dog, requires a warrant. Curtilage, the area immediately surrounding the home, is generally protected under the Fourth Amendment, but the Supreme Court has ruled that aerial surveillance does not violate an individual's expectation of privacy. In California v. Cirillo, police observed marijuana plants in a backyard from a plane at 1,000 feet. The court held that given routine air travel, Cirillo could not reasonably expect his yard to be free from aerial observation. Similarly, in Florida v. Riley, police saw marijuana through a partially covered greenhouse roof from a helicopter at 400 feet. The court again ruled that there was no reasonable expectation of privacy from lawful aerial observation. In Dow Chemical Company v. United States, the court extended this principle to industrial property, holding that enhancing vision through standard aerial cameras does not raise Fourth Amendment concerns, especially when the property is not a home or curtilage. Despite these rulings, some states provide stronger privacy protections. Vermont, in State v. Bryant, and New Mexico, in State v. Davis, require warrants for aerial surveillance of curtilage under their state constitutions. Many states are now passing laws restricting police drone surveillance, generally requiring warrants except in emergencies. In short, while curtilage is protected from physical intrusion, it carries limited protection from lawful aerial observation, even with new and emerging technology. Police may seize items they observe in public areas such as streets, parks, and monuments. Private businesses open to the public are treated in a similar fashion. However, a warrant is required to enter areas restricted to employees, like offices or stockrooms. In Maryland v. Macon, a detective entered a bookstore and examined magazines that were intentionally displayed for customers. The Supreme Court held that this did not violate the Fourth Amendment because the material was exposed to the public and there was no reasonable expectation of privacy. Abandoned property is property that an individual intentionally and physically abandons. Such property carries no expectation of privacy and is not protected by the Fourth Amendment, so police do not need a warrant to seize it. Courts consider the totality of the circumstances, including where the property is found, its condition, and its type. For example, a worn-out suitcase in a dumpster is clearly abandoned, while a new, expensive purse might not be. In Hester v. United States, the Supreme Court held that jugs of moonshine dropped by a fleeing suspect were abandoned and not protected by the Fourth Amendment. Similarly, in Abel v. United States, items left in a hotel trash were considered voluntarily abandoned. In California v. Greenwood, the Supreme Court ruled that garbage left out at the curb for collection is abandoned and not subject to a reasonable expectation of privacy. Police could lawfully examine it and use the contents to obtain search warrants for a home. While garbage may reveal intimate details, placing it on the curb indicates abandonment, and the Fourth Amendment does not require a warrant for its seizure. Just by way of review, these items have an expectation of privacy and would require a warrant. Electronic surveillances of phone calls, opening luggage, entering a home, and opening and reading a private diary. These situations do not require a warrant or have any expectation of privacy, including eavesdropping on a conversation, entry onto farmland, aerial surveillance of a backyard, or examination of trash in a dumpster. In California v. Greenwood, 486 U.S. 35, 1988, the Supreme Court considered whether the Fourth Amendment prohibited warrantless searches of garbage left for collection outside the curtilage of a home. Police had received information suggesting that Greenwood was involved in drug trafficking. To investigate, they asked the regular trash collector to pick up garbage bags placed at the curb in front of Greenwood's home. When the police examined the bags, they found evidence of drug use, which they used to obtain warrants to search Greenwood's home, leading to further seizures and arrest. The court held that the warrantless search of the garbage did not violate the Fourth Amendment. The reasoning was that, for Fourth Amendment protection, an individual must have a subjective expectation of privacy that society recognizes as objectively reasonable. The court found that Greenwood exposed his garbage to the public and to third parties, namely the trash collector, so any expectation of privacy was unreasonable. In other words, items knowingly exposed to the public are not protected by the Fourth Amendment. However, there was a strong dissent by Justices Brennan and Marshall. They emphasized that sealed garbage bags contain intimate, personal information about an individual's habits and lifestyle. The dissent argued that Greenwood could not avoid placing his garbage on the curb because of a local ordinance, and that this did not mean he relinquished his privacy rights. Warrantless searches of such trash, the dissent warned, undermine the privacy protections that the Fourth Amendment is meant to secure. The case illustrates a tension in Fourth Amendment law. The majority treats garbage left for collection as abandoned property, effectively removing privacy protections. The dissent highlights that even discarded items may reveal intimate details of one's private life and deserve protection. When we look at this case, it's important to note that the practical implications are, while the police may legally search trash left in public, the decision raises a broader question about privacy, personal autonomy, and the limits of government intrusion. Several state Supreme Courts have rejected the reasoning of California v. Greenwood, and have instead interpreted their own state constitutions to provide greater privacy protections for trash. Courts in Hawaii, New Hampshire, New Jersey, Vermont, and Washington require police to obtain a warrant based on probable cause before searching an individual's garbage. These courts emphasize that state constitutions may offer broader protections than the federal Fourth Amendment, but remember, they absolutely cannot offer less. A leading example is State v. Goss in 1984, which was decided by the New Hampshire Supreme Court. In that case, a police detective suspected that John Goss was growing marijuana after observing what appeared to be a concealed grow light in his home. Without a warrant, officers twice seized sealed black garbage bags that Goss had placed in his driveway for routine trash pickup. The officers searched the bags, found evidence of marijuana use, and used that information to obtain a warrant to search Goss's home, where additional marijuana-related items were discovered. The New Hampshire Supreme Court held that, under the state constitution, Goss had a reasonable expectation of privacy in his sealed trash bags. The court reasoned that placing garbage in opaque, sealed containers demonstrates an intent to keep the contents private. Society, according to the court, recognizes this expectation as reasonable because garbage often contains the most intimate details of a person's life, including information about their habits, health, and personal activities. The court further explained that the possibility that animals, scavengers, or other individuals might access the garbage does not eliminate an expectation of privacy, just as the possibility of burglary does not negate privacy in one's home. Similarly, turning trash over to a garbage collection company does not imply consent for police searches. Individuals reasonably expect that trash will be commingled with other refuse and disposed of according to contractual and legal obligations, not searched by law enforcement. In this way, state courts like New Hampshire have chosen to prioritize privacy interests over investigative convenience, illustrating the important role of state constitutional law in expanding individual rights beyond the federal baseline. The Supreme Court addressed expectations of privacy in luggage in Bond v. United States in 2000. Stephen Bond was traveling as a passenger on a Greyhound bus that stopped at a Border Patrol checkpoint in Texas. While checking the immigration status of passengers, a Border Patrol agent walked down the aisle of the bus and squeezed the soft luggage that passengers had placed in the overhead storage bins. When the agent squeezed Bond's green canvas bag, he felt a hard, brick-like object inside. After Bond admitted ownership of the bag and consented to its opening, the agent discovered a brick of methamphetamine concealed inside clothing. Bond was convicted of drug-related offenses and appealed, arguing that the agent's squeezing of his bag constituted an unlawful search under the Fourth Amendment. The government countered that the bag was exposed to the public in the overhead bin and therefore carried no reasonable expectation of privacy. The Supreme Court rejected this argument and held that Bond had demonstrated a subjective expectation of privacy by placing his belongings inside a closed bag, even though the bag was stored in a shared overhead compartment. The court acknowledged that passengers reasonably expect others, including bus employees or fellow travelers, to move or reposition their bags as necessary. However, the court emphasized that passengers do not expect their bags to be physically manipulated in an exploratory manner designed to discover their contents. Because the agent's squeezing of the bag went beyond what is ordinarily expected in a public transportation setting, the court held that the physical manipulation of the luggage constituted a search and violated the Fourth Amendment. The court's decision highlights the distinction between incidental contact with personal property and deliberate investigative probing. The outcome might have been different if Bond had placed his luggage in the baggage compartment beneath the bus, where passengers typically relinquish control and expect handling by others. The case illustrates that expectations of privacy depend not only on location, but also on the nature of the intrusion itself. For example, this may not have been the case on an airplane. As we've already seen, the Supreme Court has generally approved the use of recording devices, aerial surveillance, and photographic technology to assist law enforcement. As technology continues to advance, courts will increasingly be asked to determine how far the police may go in using new investigative tools. In addressing these questions, the Supreme Court has developed two general principles governing the use of technology in criminal investigations. First, when police are observing areas or objects already exposed to plain view, technology may be used without a warrant to enhance what officers can naturally see. For example, in Texas v. Brown, the court held that shining a flashlight into the interior of a vehicle to illuminate a darkened area does not constitute a search under the Fourth Amendment because it merely enhances the officer's natural vision. In United States v. Knotts, the court upheld the use of a beeper placed in a container of chloroform to track a suspect's movements on public roads. They reasoned that the device revealed no information beyond what could have been observed through visual or aerial surveillance. The court explained that the Fourth Amendment does not prevent police from augmenting their sensory abilities with technology when the information obtained is otherwise publicly observable. Second, the court has drawn a firm line at the home, which receives the highest level of Fourth Amendment protection. Technology may not be used without a warrant based on probable cause to obtain information about the interior of a home that could not otherwise be learned without physical entry. This limitation was emphasized in United States v. Caro, where the court held that police violated the Fourth Amendment by continuing to monitor a beeper after the container was taken inside a private residence. Although officers could not lawfully enter the home without a warrant to confirm the container's presence, they likewise could not use electronic monitoring to accomplish the same objective indirectly. Together, these cases illustrate the court's effort to balance technology's progress with constitutional privacy. While technology may enhance police observation in public spaces, it may not be used to penetrate the privacy of the home without judicial authorization. In Kylo v. United States 533 U.S. 27, 2001, the Supreme Court confronted the question of whether police use of thermal imaging technology to detect heat patterns inside a home constitutes a search under the Fourth Amendment. Federal agents suspected Danny Kylo of growing marijuana inside his residence based on tips and unusually high electricity usage. To confirm their suspicions, officers used a thermal imager from a public street to scan Kylo's home and compare its heat levels to neighboring units. The scan revealed unusually warm areas consistent with the use of high-intensity grow lights. Relying in part on this information, agents obtained a warrant and discovered an indoor marijuana operation. The government argued that the thermal scan did not constitute a search because it merely detected heat radiating from the exterior of the home and revealed no specific details about activities inside. The Ninth Circuit accepted this reasoning, concluding that Kylo had no reasonable expectation of privacy and heat escaping from his house, and that the scan exposed no intimate details. Justice Scalia, writing for the majority, rejected this approach and emphasized that the home occupies a central place in Fourth Amendment doctrine. The court reaffirmed that the home receives the highest level of constitutional protection, and that, with few exceptions, warrantless searches of a home are presumptively unreasonable. The court acknowledged that technological advances have already reduced privacy in some contexts, such as through aerial surveillance, but warned that unchecked technological enhancements could erode the core privacy the Fourth Amendment was designed to protect. The court held that when the government uses sense-enhancing technology, that is, not in general public use, to obtain information about the interior of a home that could not otherwise have been obtained without physical intrusion, the surveillance constitutes a search. It did not matter that the technology revealed only heat patterns rather than visual images of people or activities. All details of the home are considered intimate for Fourth Amendment purposes, simply because they are details of the home. Allowing the government to gather such information without a warrant would leave homeowners vulnerable to increasingly sophisticated technologies capable of revealing private life without physical entry. The court also rejected the argument that the thermal imaging was permissible because it detected only external heat. Drawing on cats, the court explained that constitutional protection does not depend on the medium through which information escapes. Just as recording sound waves outside a phone booth constitutes a search, in cats, detecting heat patterns that reveal information about the interior of a home likewise implicates the Fourth Amendment. The court emphasized the need for a bright-line rule at the entrance to the home. Without such a rule, advancing technology could gradually eliminate the privacy the Fourth Amendment was intended to secure. Accordingly, the court held that the thermal imaging of Kylo's home was a search and was presumptively unreasonable without a warrant. The case was remanded to determine whether the remaining evidence supported probable cause. In his dissent, Justice Stevens argued that the officers observed only what was exposed to the public, heat emanating from the outside of the home, and that the thermal imager merely assisted ordinary sensory perception. He warned that the majority's rule was unnecessary, vague, and potentially counterproductive, particularly because its protection diminishes once technology becomes widely available. Stevens also expressed concern that the court was prematurely constitutionalizing issues better left to the legislature. Ultimately, Kyllo stands for the principle that technological surveillance aimed at the home triggers Fourth Amendment scrutiny when it reveals information that would otherwise require physical intrusion, reinforcing the home's status as the core zone of constitutional privacy. However, when I was in law school and we were discussing this case, one thing that we discussed was, what if it had been winter? What if there had been snow on top of Kyllo's home? At that point, the heat protruding from the home would have caused the snow to melt on his roofline in an odd fashion. It would have been melted over here in this section, but not melted over here in this section. And at that point, could officers use that, by observing the heat emanating from the home, to be the basis for their probable cause for a search warrant? Everyone agreed that, of course, if they observed this on the snow, then it would be reasonable and it was in plain view. Why is the use of this technology what makes it unreasonable? Just something to consider. In United States v. Jones, the Supreme Court considered whether the warrantless attachment of a GPS tracking device to a vehicle followed by long-term monitoring of the vehicle's movements violated the Fourth Amendment. Writing for the majority, Justice Scalia held that the government conducted a search because it physically trespassed on a constitutionally protected area by attaching the GPS device to Jones's car for the purpose of obtaining information. This trespass-based approach focused on the physical intrusion itself, rather than on any reasonable expectation of privacy in the vehicle's public movements. Justice Alito, concurring in the judgment, relied instead on a privacy-based analysis and concluded that long-term GPS monitoring infringes on reasonable expectations of privacy because it allows the government to comprehensively track a person's movements over time. He emphasized that while short-term public surveillance is expected, society does not anticipate prolonged, secret monitoring of an individual's daily life. Together, the opinions illustrate the court's competing approaches to modern surveillance, balancing historical property-based protections against evolving privacy expectations in the digital age, but ultimately, the court all reached the same conclusion. In Grady v. North Carolina, the Supreme Court considered whether requiring a repeat sex offender to wear a satellite-based monitoring ankle bracelet for life constituted a Fourth Amendment search. The court held that continuous GPS monitoring involves a physical intrusion on the body for the purpose of obtaining information and therefore certainly qualifies as a search. Rather than deciding constitutionality outright, the court remanded the case for a determination of whether the search was reasonable under the totality of the circumstances, emphasizing that even searches of convicted offenders must satisfy Fourth Amendment standards. Several courts and legislatures have concluded that law enforcement must obtain a warrant supported by probable cause to use cell site simulators, commonly known as stingray devices. These devices mimic cell towers and force a targeted phone to reveal its unique identifier and location, allowing police to track an individual's movements. Courts have taken different approaches to analyzing their constitutionality, but many emphasize the intrusive nature of exploiting a cell phone's operation without judicial oversight. In Prince Jones v. United States, the D.C. Court of Appeals held that warrantless use of a stingray constitutes an unreasonable search because it forces individuals to either accept the risk that their phone may be covertly converted into a tracking device or forego use of a technology that is essential to modern life. The court reasoned that the government may not exploit this technological vulnerability to diminish a person's legitimate expectation of privacy. Geofence warrants, also known as reverse location searches, authorize the government to collect location data from all devices within a defined geographic area during a specific time period in which there is probable cause that a crime has occurred. This form of surveillance is similar to geolocation tracking, but it's not the same because it typically identifies only whether and when a device enters or leaves a particular area, rather than continuously tracking an individual's movements over time. Geofence warrants usually operate in stages, beginning with a provider such as Google producing anonymized location data for all devices in the geofence, followed by law enforcement narrowing the pool of devices and ultimately seeking identifying information for selected accounts. Although courts in several jurisdictions have issued geofence warrants, critics argue they are constitutionally overbroad because probable cause may exist as to one unknown suspect, but not as to the many innocent individuals whose devices are swept into the search. This concern is especially acute in urban areas and echoes Ybarra v. Illinois, which held that a warrant to search a place does not justify searching every person present, highlighting the Fourth Amendment's requirement of individual probable cause. In Carpenter v. United States 585 U.S. 296, 2018, the court addressed whether the government conducts a search under the Fourth Amendment when it accesses historical cell site location information, or CSLI, that tracks a person's movements. Police investigating a series of robberies obtained 127 days of Carpenter's CSLI from his wireless carriers, generating 12,898 location points, which showed where he had been at nearly every moment of each day. CSLI records each connection a cell phone makes to a cell tower, producing a detailed and nearly continuous record of the user's physical movements. Carpenter argued that the government's acquisition of this information without a warrant violated his Fourth Amendment rights. The Supreme Court held that the Fourth Amendment protects people, not just places, and that long-term comprehensive digital tracking implicates reasonable expectations of privacy. While limited tracking, such as the intermittent use of a beeper or a short-term GPS monitoring, does not constitute a search in some circumstances, CSLI provides an all-encompassing record of a person's movements, revealing intimate details of life, including home, work, religion, and social patterns. Unlike telephone numbers or bank records considered in early third-party doctrine cases, CSLI is generated automatically and continuously as part of everyday cell phone use, so the user does not meaningfully share it voluntarily. Because the information is highly revealing, the government's access to it without a warrant constitutes a search under the Fourth Amendment. The court concluded that law enforcement generally must obtain a warrant supported by probable cause to access historical CSLI, although exigent circumstances such as pursuing a fleeing suspect, preventing imminent harm, or stopping the destruction of evidence may justify a warrantless search. The court emphasized that the pervasiveness and precision of modern cell phone tracking creates new privacy concerns that require protection, even when the information is held by a third-party service provider. The decision established that individuals maintain a reasonable expectation of privacy in the comprehensive record of their personal, physical movements captured by their cell phones. Justice Kennedy, joined by Justices Thomas and Alito, dissented, emphasizing the investigative importance of cell site records. Carpenter and his accomplices had committed multiple armed robberies over a 2-year period across a wide geographic area, and cell site data provided crucial circumstantial evidence linking suspects to specific robberies. The government obtained the records through federal magistrate judges under the Stored Communications Act, which requires the government to show specific and articulable facts that the records are relevant and material to an ongoing investigation. Kennedy argued that this judicial oversight mitigated concerns about overly intrusive surveillance. He noted that the records were owned and controlled by a third-party service provider, and not Carpenter himself, and therefore Carpenter had no reasonable expectation of privacy in them. The data only revealed general location information across broad sectors and could not disclose intimate details of a person's life. The dissenters stressed that the court's decision creates an arbitrary line, such as the suggested 6 or 7 day threshold, and disrupts the legislative framework established by Congress for accessing cell site records. They warned that the ruling could hinder law enforcement investigations into serious and ongoing crimes and produce uncertainty about how courts should handle other types of third-party business records in the future. Justice Alito, joined by Justice Thomas, also argued that there is a clear distinction between actual searches of private property and the compulsory production of records maintained by a third party. The order to obtain Carpenter's cell site records did not intrude upon Carpenter's person or property and fell within established legal standards for compelling document production. Alito emphasized that Carpenter had no ownership, possession, or meaningful control over the records, which were created, maintained, and ultimately destroyed by the service providers. He argued that extending Fourth Amendment protections to such third-party records is inconsistent with the text and history of the amendment, which protects persons, houses, papers, and effects. In the dissenter's view, the majority's decision represents an unnecessary and potentially disruptive expansion of Fourth Amendment doctrine. Let's move on from searches and move into seizures. The drafters of the United States Constitution sought to protect individuals as well as their houses, papers, and effects from unreasonable searches and seizures. A Fourth Amendment seizure occurs when a law enforcement officer detains a person and restricts their freedom of movement. The level of justification required for a seizure depends on the extent of the interference with individual liberty. An arrest that may result in taking a person into custody, along with a search incident to that arrest for weapons or contraband, requires probable cause. A brief investigative stop, by contrast, may be justified by reasonable suspicion and allows only a limited frisk for weapons. The Supreme Court has also recognized a third category of interactions known as encounters, which are voluntary, non-coercive contacts between police and citizens that do not constitute seizures. Not all street or public interactions between officers and the public restrict freedom of movement or trigger Fourth Amendment protections. In United States v. Mendenhall, the court explained that characterizing every interaction as a seizure would impose unrealistic restrictions on legitimate law enforcement practices. In that case, federal drug agents approached Sylvia Mendenhall in an airport, identified themselves, and asked to see her identification and airline ticket. Mendenhall appeared nervous, and the agents escorted her to an office nearby, where she consented to a body search that uncovered heroin. The Supreme Court held that this was not a seizure because Mendenhall had not been physically restrained, and the officer's initial approach and questions did not compel her compliance. Officers returning her identification and ticket before asking her to accompany them to the office was a central factor in the court's decision. Courts assess the totality of the circumstances to distinguish a seizure from an encounter, and the line can be unclear. Circumstances suggesting a seizure might include a threatening show of force by multiple officers, displaying a weapon, physical touching, or language implying that compliance is compulsory and not voluntary. The lesson is that police must recognize the distinction between seizures and encounters. If Mendenhall's interaction had been deemed a seizure without sufficient justification, the discovered drugs could have been excluded as the fruit of an illegal detention. The recognition that not all police contacts are seizures aligns with the American Law Institute's Model Code of Pre-Arraignment Procedure, which permits officers to request voluntary responses or appearances without deeming compliance coerced solely because the request comes from law enforcement. An individual is considered seized in two separate ways. Through a physical seizure, where an officer takes hold of a suspect to prevent their departure, or through a show of authority, where an officer demonstrates official power in a manner that a reasonable person would not feel free to ignore or leave. In a show of authority seizure, the individual must actually submit to the officer's display of control. In summary, a seizure occurs when an individual is either physically restrained or, in response to a show of authority, reasonably believes they cannot leave and submits to that authority. The distinction between a seizure and an encounter is not always clear, and courts carefully examine the circumstances to determine whether Fourth Amendment protections apply. In Immigration and Naturalization Service v. Delgado, federal agents carrying walkie-talkies entered a factory, blocked the exits, and questioned workers about their legal status. The sweep lasted between 1 and 2 hours. the Supreme Court noted that the workers' freedom of movement was not restricted by the agents, but by their voluntary presence at work, and therefore the interaction did not constitute a Fourth Amendment seizure. Do you agree with this? It was a very controversial case at the time. In Florida v. Bostick, two sheriff's deputies, one openly armed, boarded a crowded interstate bus and approached Terrence Bostick in the back. They asked him a few questions and requested permission to search his luggage. The officers did not threaten him, display weapons, or otherwise coerce him, and Bostick consented to the search, which revealed illegal narcotics. The court held that the relevant question under the Fourth Amendment is whether a reasonable person, considering the totality of the circumstances, would feel free to decline the officer's request or terminate the encounter. Similar reasoning was applied in United States v. Drayton, where bus passengers voluntarily complied with police requests without coercion. In Michigan v. Chesternut, 4 officers in a squad car observed a man approach Michael Chesternut. Chesternut fled, and the officers followed him briefly without activating sirens or flashers, displaying weapons, or blocking his path. Chesternut discarded 4 packages, one of which contained illegal narcotics. The Supreme Court held that Chesternut could not reasonably have believed that the officer's mere presence, considered in the context of all surrounding circumstances, restrained his liberty so that he was not free to leave. The book has mistitled this case only slightly. It's important to know that this case is titled California v. Hodari D. 499 U.S. 621, 1991. In April 1988, officers Brian McColgan and Jerry Pertoso were patrolling a high-crime area in Oakland, California, dressed in street clothes with jackets labeled police. While driving in an unmarked car, they spotted a group of youths huddled near a small red car. When the youths saw the officers, they scattered. Hodari D. ran through an alley while others fled in different directions, and the red car sped away. Officer Pertoso chased Hodari D. on foot, and as Hodari D. ran, he discarded what appeared to be a small rock. Pertoso then tackled Hodari D., handcuffed him, and called for assistance, discovering that the discarded rock was crack cocaine. Hodari D. moved to suppress the evidence, arguing that the cocaine was the fruit of an unlawful seizure. The California Court of Appeals agreed, reasoning that Hodari D. had been seized when he saw the officer approaching, making the seizure unreasonable and requiring suppression of the drugs. The California Supreme Court denied review, and the United States Supreme Court granted cert. The key question before the court was whether Hodari D. had been seized under the Fourth Amendment at the moment he discarded the cocaine. If he had been seized, the evidence would have been tainted. If not, the drugs were abandoned and lawfully recoverable. California conceded that Officer Pertoso lacked the reasonable suspicion to justify stopping Hodari D. The court explained that a Fourth Amendment seizure occurs through physical force or, if force is absent, submission to a show of authority. Since Hodari D. had not yet submitted to Pertoso's show of authority while running, no seizure had occurred when he discarded the cocaine. The court held that a seizure requires either touching or submission, and mere pursuit or verbal commands do not constitute a seizure if the individual does not yield. Therefore, the cocaine abandoned while Hodari D. was fleeing was not the fruit of a seizure, and the trial court properly admitted it. In his dissent, Justice Stevens, joined by Justice Marshall, agreed that no arrest had occurred until Hodari was tackled, but argued that the officer's pursuit amounted to a show of authority that would have conveyed to a reasonable person that they were not free to leave. Under the Mendenhall standard, a seizure occurs when a reasonable person would believe they were not free to depart, and Stevens contended that Hodari D.'s flight reflected that he had not voluntarily submitted, but still had been effectively seized by the show of authority. The dissent warned that the majority's rule, which ties the moment of seizure to citizen submission rather than the officer's conduct, could undermine Fourth Amendment protections by allowing aggressive displays of force that might frighten individuals without immediate accountability. In Hodari D., the Supreme Court addressed seizures that occur through a show of authority rather than through physical contact. The court held that a person is only considered seized under the Fourth Amendment when they submit to the officer's show of authority or are physically restrained. Mere pursuit, verbal commands, or attempts to stop someone do not constitute a seizure if the person continues to flee and does not yield. The focus is on whether the suspect submits, although the test is framed objectively. Would a reasonable person understand they were not free to leave? In the case, Hodari D. was not yet seized at the moment he discarded the drugs because he had not submitted to the officer's authority. By contrast, Torres v. Madrid clarified the standard for physical seizures, which occur when an officer applies force to the body with the intent to restrain a person's movement. The court adopted a mere touch rule, holding that even minimal physical contact can count as a seizure if there is an intent to restrain, regardless of whether the person actually submits or is subdued. The test is objective, focusing on the officer's conduct and intent rather than the suspect's perception. In Torres, the court held that when officers shot at Torres to stop her vehicle, they applied physical force with the intent to restrain, which constituted a seizure, even though Torres initially continued to flee. The distinction between these two types of seizures is important. In show of authority situations, a seizure requires submission to the officer, while in physical force situations, a seizure occurs when the officer intentionally applies force to restrain movement. In show of authority cases, courts ask whether a reasonable person would feel free to leave, whereas in physical force cases, the inquiry focuses on whether the officer intended to restrain the suspect. Having two different approaches makes sense because fleeing suspects, voluntary submission, and physical restraint all present different implications for individual liberty and public safety. Without Hodari D.'s rule, any chase or verbal command could count as a seizure, which would make the Fourth Amendment overly broad. Torres ensures that physical force, which directly restricts a person's liberty, is properly recognized as a seizure. Together, these cases illustrate how the law balances protecting a citizen's freedom against practical law enforcement needs. Law enforcement increasingly employs dogs to detect narcotics, explosives, and other contraband in airports, subways, train stations, and shipping containers. Dogs are even used in military operations to detect landmines and have been trained to detect medical conditions such as cancer. Dogs are currently used at over 73 ports of entry into the United States and are often described as far more efficient than humans at detecting contraband. The Fourth Amendment raises the question of whether exposing a person's property to a dog constitutes a search. In United States v. Place, the Supreme Court addressed this issue when DEA agents in New York suspected Raymond Place of carrying narcotics. Place refused consent for a search of his luggage, so agents transported the bags to JFK Airport, where a trained narcotics dog indicated the presence of drugs. Based on this alert, a magistrate issued a search warrant, and agents discovered 1,125 grams of cocaine. Place argued that the dog sniff was an unconstitutional search. The Supreme Court held that a canine sniff is one of a kind. The sniff is limited both in how the information is obtained and in the type of information revealed. It only indicates the presence or absence of narcotics and does not require officers to search through luggage or its contents. Therefore, the court ruled that a dog sniff does not constitute a Fourth Amendment search. Later, in Illinois v. Cabela's, the court held that using a dog to sniff a vehicle during a lawful traffic stop does not violate the Fourth Amendment, so long as the sniff does not prolong the stop. A dog sniff during a lawful detention that reveals no private information beyond the presence of contraband is not a constitutional violation. Despite these rulings, the reliability of dogs is not absolute. Justice Souter, in his dissent in Cabela's, noted that the infallible dog is largely a legal fiction. Errors by handlers and dogs in controlled testing show false positive rates ranging from 12.5 to 60%. The Supreme Court addressed canine reliability more directly in Florida v. Harris. In that case, Clayton Harris was stopped for driving with an expired license plate, and a trained dog named Aldo alerted to the presence of narcotics. A search revealed ingredients used to manufacture methamphetamine, but no narcotics. Harris argued that the dog's alert did not provide probable cause because Aldo's reactions were unreliable. Officer Wheatley testified that Aldo had completed 3 training courses in 2004 and 40-hour refresher course in 2005, in addition to weekly training exercises. Training logs indicated that Aldo always found hidden drugs and received a satisfactory performance rating. However, Wheatley admitted that Aldo's certification had expired the previous year and that field performance records were incomplete. The Supreme Court noted that field performance is an unreliable measure of a dog's accuracy because it is impossible to know whether a dog failed to detect narcotics or was responding to residual odors. By contrast, controlled training and certification provide a verifiable measure of reliability. The court concluded that Aldo's training record was sufficient to establish reliability. Evidence of a dog's satisfactory performance in a certification or training program can itself provide probable cause for a search. However, questions remain about whether the court places too much confidence in training procedures as a measure of accuracy in real-world situations. In conclusion, the Fourth Amendment protects individuals against unreasonable searches and seizures and effectively abolished general warrants and writs of assistance by requiring probable cause and specific descriptions for warrants. While the Supreme Court prefers that police obtain warrants, it is recognized that limited reasonable warrantless searches are permissible in certain circumstances. Originally, the court applied a property-based approach, protecting against physical intrusions into houses, papers, and effects. In 1967, Katz v. United States shifted the focus to privacy rights, establishing that the Fourth Amendment protects expectations of privacy that are both personal and recognized as reasonable by society. This privacy-based approach is limited, as individuals generally lack privacy in public spaces, commercial areas, abandoned objects, and information voluntarily given to third parties. The court has drawn strong protections around the home, as in Kyllo v. United States, holding that the government may not use technology to gather information about the interior of a home without physical intrusion. Seizures of persons require either probable cause or reasonable suspicion. A seizure may occur through physical restraint or a show of authority that leads a reasonable person to believe they cannot leave, and the individual must submit. The court has clarified that not all police-citizen interactions constitute a seizure, allowing officers to engage in voluntary encounters and questioning without satisfying these standards. Overall, the Supreme Court has sought to balance individual privacy against the needs of law enforcement. Full Fourth Amendment protections apply in private areas that society recognizes as deserving privacy, while public spaces and information shared with third parties generally have limited protections. Police must justify seizures on factual grounds, but they retain flexibility to engage in voluntary encounters. Later chapters will explore reasonable suspicion, stop and frisk, probable cause searches and seizures, special needs searches, and the exclusionary rule, providing a complete picture of how the Fourth Amendment operates in practice. I'll see you in Chapter 4.